Hello, I'm Chris Dale of the UK-based eDisclosure Information Project. The role of that is to bring information about eDiscovery between lawyers and clients and courts and those who supply into the market, and to try and get them all on the same page, all understanding the issues that the other faces and what is on offer from the various players in this market. I have with me Steve Akers, founder and CTO of Digital Reef, a company whose business is information governance and eDiscovery, and Peter Mansmann, CEO of Precise Litigation support company. Our subject is strategies, tools and techniques for preparing discovery data for review. And the traditional way in which that's debated or discussed is to talk about rules, to talk about the EDRM, and to waive the threat of sanctions, and leave it at that. We'd like to adopt a rather different approach and look at the objectives that what are we trying to achieve with this exercise. I'm going to start by asking my colleagues here to explain who they are. Steve, we're not here to promote Digital Reef particularly, but tell us what Digital Reef does in your role.
Thank you, Chris. Yes, I'm the founder of Digital Reef. We're a 5-year-old company dedicated to providing technology primarily to our partners and to customers for aiding their discovery efforts, but more generally to kind of help them understand the kinds of data they have and be prepared strategically for when something strikes. We think it's better to be a bit proactive than totally reactive.
So that ties in well with our theme. Pete, what does Precise do?
I'm CEO and founder of Precise Inc., which was founded in 2000. We're based out of Pittsburgh, Pennsylvania. Precise is basically a two-sided company. One part of our company focuses on trial presentations and presenting evidence at trial. The other side of our company is focused on discovery, from retention plans to traditional discovery work, forensics work, and I've largely spent my time the last 7 years in the discovery department in a heavy sort of consultative role in helping lawyers put together their discovery plans.
Excellent. The objectives, the client's objectives and the court's objectives, they tend to get forgotten in this scramble to avoid being sanctioned, the big bogeyman of US discovery. It isn't really a binary choice between being sanctioned and preserving everything. People run it as if you either mess it up or you preserve everything that you could possibly have. And there's a middle course somewhere. And instead of trudging through this idea that you must preserve everything or the court will sanction you, we'd like to look at a rather different way of doing it. Knowing what you've got, or getting your arms around the problem, is the way we'd like to encourage you to think about this. Because once you know what you've got, all sorts of other positive things can flow that will allow you to walk that line between being sanctioned and preserving everything. How much do your opponents need? How much do you need? How much does the court expect from you? These are intelligent questions to be asking at the outset, instead of waiting until you get hit with a complaint from the other side or from the court. I'm from the UK, and the rules in my jurisdiction, as in yours, require cooperation in litigation. And it's a concept that people talk about without really understanding, perhaps, what the positive virtues are of cooperating with the other side. It's seen as treason by many lawyers. You can't cooperate, assuming that you buy the idea that cooperation is a good thing. You can't cooperate if you don't know what you've got. And clients, there's a separate problem. Clients are reluctant to spend money at this stage of finding out what you've got. They are, of course, their documents, and they ought to know something about it. So one element coming from the consultative process that you talk about, presumably, is reminding the clients that it's their documents and looking to them for help. We'll come back to that in a minute, but it's a point I like to make often. The clients can't complain too much if they don't know their own systems, perhaps. The objectives in the US rules, in FRCP Rule 1, are the just, speedy and inexpensive determination of every action and proceeding, which again conflicts somewhat with the idea that people feel they must preserve everything or be sanctioned. We have something similar in the UK. We call it the overriding objective, And that's supported by a strong duty, a stronger duty in many ways than US judges have, to manage cases actively. So there's the judge getting involved in a way, in fact, that US judges are increasingly doing. They're increasingly seeing their role as helping to direct what happens. And they're getting pushback, US judges, about the cost of this particular aspect of litigation. And some of them are beginning to realise that those clients that are giving them this grief over the cost of it are the very people who actually ought to be able to do something about it. They're the ones, as I've said, who own the documents. They're also the ones who direct, or who should direct, how their lawyers run the litigation. And this circle is beginning to become clearer. Judges are beginning to focus on the idea that the clients can't just come whining and saying the whole procedure is very expensive if they haven't, to some extent, taken their fate into their own hands. We have, as I see it, three broad problems. We have a lack of basic competence. People don't understand the rules. Well, you'd think a lawyer would at least understand the rules, wouldn't you? Not just know them, but understand their implications. We have a problem of competence in relation to technology. No one's expecting the lawyers to understand how this stuff works, but one does at least expect them to know what exists, know what it costs, know what it can save, and what contribution it can make to the overall process. And lawyers are pretty lousy on the whole of project management, which is a skill of its own, and one which the likes of Pete presumably can help bring to them. The general idea that you outsource things you're not good at, project management and litigation, is one of them. The second problem, as I see it, is this problem about cooperation, the reluctance on the part of lawyers to cooperate because they think that their duty is to fight in every last ditch. And some clients indeed want that. They want people to fight every possible corner. One wonders sometimes if they understand how much that costs. The third area is judicial acceptance of this technology, or at least a perception on the part of lawyers that judicial acceptance is something we need to wait for. We are at the moment, as I see it, in a sort of hiatus period where there's a lot of fantastic technology out there, and quite a lot of people who know how to use it, but a reluctance to use it for fear that a judge will say, no, go back and use keywords or something that I, the judge, understand. I myself see that as a failure to, on the whole, to explain to the judges clearly what the potential is for these applications. We're very good at explaining the issues and taking them through the facts. The lawyers need to get better, I think, at taking them through all the implications of the technology. So what's the answer? Well, there's no easy answers, and anybody who purports to tell you that there's an easy answer is lying. You've got to know what you've got as sources. That's clearly a key point right at the top, getting, as I put it earlier, getting your arms around the problem. And you want to do that quickly and cheaply, right up front, because it's that informs everything else, including the estimates of the costs that are going to be incurred as you go along. You want to be able to discriminate very early between what matters and what doesn't, what really matters, not just what's going to get me sanctioned, but what actually matters in this case, in a way that allows you to argue your position against your opponents and against the court. You need to be able to justify your decisions. If in fact, in the event you've missed something, you're not going to get sanctioned if you can show the good faith, the steps that you took. Mere mistake. And we're beginning to see a reaction, I think, in the US. Judges beginning to realise that sanctions, to some extent, are counterproductive. That doesn't mean they don't have a place. Judge Laporte recently said that you've got to have a policeman on the block, and that's entirely right. But I think we're seeing a move away from sanctions for procedural defects for those who are in a position to explain how they arrived at the answer they've got. All this gives you a confidence as a lawyer, the same ability, as I said earlier, as you assume you have to argue about the issues. And if you can do that argument, run that argument properly, or if you're the client, you're alert to the fact that your lawyers are capable of doing that. So in a sense, it's the client's responsibility as well, this whole aspect. You could get to the position where you're forcing the other side either to agree that you're right or to put up a different and a better way of doing it, because you're speaking from a position of being informed and knowledgeable. And one can sometimes put them into the position of having to argue for a more expensive route, and that shifts the burden in a way that is tactical, but is tactical in a good way, as it were. That much by way of introduction, really. We have in the UK a questionnaire, which I took part in drafting. Have you really seen our questionnaire?
I have, and I was just going to ask you if that standardization was starting to take hold and help.
The idea is that in certain litigation, parties are made to explain to set out on paper what their sort of structured way, what their sources are, what the problems are, what do you anticipate as the difficulty, and to exchange that. And we're finding that in a lot of cases, even where the rules don't require that, parties are saying, this is not a bad idea. Not only are we forced ourselves to find out what we've got, but we're going to get in as a trade the information from the other side, which not only helps us to scale the thing, but it also helps us to take a stab at what the cost is going to be.
Mm-hmm. Yeah, it had a lot of practical common sense things that anyone could benefit from.
Do you see anybody using it over here voluntarily?
I can't say as I know anyone using it, but the steps are becoming better now. I think our industry, and Peter would probably be better to comment on this, has become, it's in the first stage of its evolution. For an industry that's supposedly a niche and has been around for a number of years, it's remarkably unevolved. And when I get to speaking about the technology, I think there's some responsibility on the vendor side and on the legal side for that. But I think we're going to see tremendous innovation, and it's going to start with things like your questionnaire that help lead us to some obvious conclusions that boil down the technological choices.
Actually, the Western District of Pennsylvania, where I'm located, has a set of local rules that are
Judge
similar. Yes.
Yes, she's great.
She is, and one of the additional requirements they have in the Western rules, which I think is also a very good thing, is the requirement at the onset of the case that you have designated a resource person for your eDiscovery questions, and that I think really helps get through a lot of the questions and inevitable I don't knows that happen early on in the stages of planning these things out.
We're increasingly hearing from both US and UK judges, and as I see it, it's an interesting development, complaints by them about companies who ought to know better, serial litigants, companies who turn up in front of their courts quite often, and who aren't ready. We have a case in England, Earls against Barclays Bank, where a company was actually penalised in costs because it couldn't produce documents which it ought to have been able to produce. Not punished for misconduct so much as you should have been ready, and you weren't. And that's a good example of the increasing intervention that we're seeing by the courts.